in this video, we will be covering the entire revision of this chapter 8, which is declaration and payment of dividend. And this chapter is important for CS students as well as CMA students. And if we analyze how important this chapter is, now this is what you can see as the bird's eye view of how many marks this chapter is being asked. Now, right from May 2018 to May 2024, if we analyze, the marks that are being asked are, on an average, it is coming for 5 marks. So minimum is 5 marks that it is coming for. And there were attempts like November 20 when a question is asked for 8 marks. Of course, there are attempts where like December 21 and May 22, which are affected by COVID and other restrictions, where the weightage out of this chapter was remarkably low, but we are not sure, maybe they would have asked MCQ questions, so which is not part of this analysis. All this is part of that 70%. So out of 70, even if we take the average of 5 marks, 5 marks out of 70 is also a good number. So keeping this point in mind, let us start our discussion and our conclusion on this entire chapter in this video. Now, how I will be taking you through this video is, first, let us discuss the chapter as it is. I will take you through the important points from the examination perspective, and then we will have a look at the MCQs that are being asked and the short answer questions that are being covered, and as well as the case study questions. We cover all 3 types of questions to the extent as much as possible. Now, let's start with this. When we talk about this declaration and payment of dividend, the first and foremost point that we need to consider is about the word dividend. Let's discuss this definition of the word dividend, which is a basic one at this stage. Dividend, here it's a very simple definition. Dividend includes interim dividend. And then what do we mean by dividend? Dividend, as we know, it is something which is paid to the shareholders as a reward for their contribution towards capital, and which is paid totally out of profits. So that is why the statement, dividend is a payment made by the company to its shareholders and as a distribution of profits. So this is a very basic one. Let's move ahead. And this dividend is of 2 types. One is interim dividend and second one is final dividend. And interim dividend, as explained in the material, these are the differences between interim dividend and final dividend. Interim dividend is the dividend which is declared during the financial year, whereas this final dividend is the dividend which is declared based on the actual profits, the accounts of which are considered in the AGM, and the members are going to approve the dividend what has been recommended by the board of directors. So to begin the actual differences between interim dividend and final dividend, interim dividend, as it is highlighted here, interim dividend is which is declared and paid during the accounting year. Whereas if you look at final dividend, this is paid after the closure of the year, and which is then moving on to the second point. This one is something which is decided by the board of directors. So they decide and they approve. So there is no involvement of shareholders as far as interim dividend is concerned. But when it comes to final dividend, this is something which is recommended by the board of directors and which is approved by the shareholders. So recommendation is by the board of directors and approval is by the shareholders. But here he may ask you one important question in the examination, that is, can the shareholders approve higher rate of dividend than what is recommended by the board of directors? So no doubt the shareholders are the owners of the company. However, when it comes to dividend, the shareholders do not have the power to approve for a rate which is higher than what is recommended by the board. They can modify, but the modification should be only on the lower side. But the approval by the shareholders cannot be on the higher side. They cannot increase the rate of dividend than what is recommended by the board of directors. Kindly mark this point as 3 stars. There are questions that we see at a later point of time which he is asking to test your understanding of it. Then continuing our differences, the third point of difference between interim dividend and final dividend, this is something, because as we discussed, the first point and the third point is having a linkage. When we say that this is which is declared and paid during the accounting year, obviously this is all happening before preparation of the financial statements for the year, because the year itself is not over. Whereas this final dividend is something which is prepared after the preparation of the financial statements. And the next point of difference is on the revocation. This again is an important point. Kindly make a note of it. There are questions on this. Can this interim dividend be revoked? That is, revoking is cancellation after declaring. Now, can this interim dividend be revoked? The answer is yes, but only thing is they require the consent of the shareholders. But when we talk about the final dividend, in general, they cannot revoke it. Though this is what is referred in the point of difference table. However, what happens if there are severe financial difficulties for the company after declaring the dividend? If there are the financial difficulties for the company in honoring this commitment, whatever they have made in the AGM, then the company will have to apply to the tribunal, and the tribunal is the one. The tribunal will decide based on the merits of the case, they will allow to revoke it. But let us not get into that complicated one. As of now, the final dividend cannot be revoked. This is in general. As I said, exception is through this, the NCLT permission. That is what we can look at it. If we look at the difference between these two statements, this is the general statement. Dividend once declared cannot be revoked. So this is the general statement. However, such dividend, the revocation is possible if they are able to get the approval of the tribunal. And when is the tribunal is going to give them the permission? Only when there are huge financial losses due to which the company is not able to honor. And going by the practical cases, the tribunal will consider any natural calamities which are causing these huge losses as a reason for giving this approval. So, if at all he is asking a question, can final dividend be revoked? The answer, general answer, how you have to start is, you have to start with the general statement, it can be revoked. However, this is an exception. Exception is with the NCLT approval. The background for that, when do we get NCLT approval? There must be a huge financial loss, and the reason for that loss must be natural calamities. Now, coming back here, then what are the power of articles? Now, do we need to have this power to declare this interim and final in the articles? Now, when we talk about interim dividend can be declared only when the articles permit. So this word only is important. So only when the articles permit, they can declare interim dividend. For when it comes to this final dividend, irrespective of you contain a provision or you do not contain a provision in the articles, this dividend can be. So that is, it does not require any specific provision in the articles. So these are the differences between interim dividend and final dividend. As a quick recap, interim dividend is the one which is paid during the year. This is the one which is paid after the closure of the year. And interim dividend, members have no role in it. It is the directors who would decide and approve. When it comes to final dividend, there are two parties involved. One is the board of directors, second one is the shareholders. Board recommends the rate which the shareholders approve it. Then the third point of difference is the status of completion of financial statements. If you are talking about interim dividend, at the stage of declaring interim dividends, financial statements are not yet prepared. Interim financials may be prepared, but we are talking about the final set of financials. Since this is declared during the year, obviously financial statements are not prepared at this stage. Whereas final dividend, since it is based on the approved and audited financial statements, the financial statements are already prepared and it is even audited. And revocation, both can be revoked, but as a general statement, we say that final dividend cannot be revoked unless exempted by, unless you got an approval from NCLT. When it comes to interim dividend, it can be revoked with the approval of the shareholders. And the power of articles, it is required for AOA, the specific provisions are required, but for final dividend, specific provisions are not required. So with this, we conclude our discussion on interim dividend and final dividend. Now, moving further to the topic, based on the payment of dividend, how do we divide the shares? The shares are, and what are the rights of each of the shareholders in terms of their receipt of dividend? Now, as we all are aware, the shares are of two types, preference shares and equity shares. And the preference shares are again of two types, cumulative preference shares and non-cumulative preference shares. This being a basic point, I'm not going to dwell too much into it, but still let's cover it, whatever the summary it is required to be covered. Now the cumulative, as we are aware, for any reason, if the company could not make the payment of dividend for want of funds, etc., then the unpaid dividend gets accumulated. And till what period it accumulates? It accumulates till the time it is actually paid. Whereas when it comes to non-cumulative, any areas of dividend which the company could not make it will never get accumulated. That is why we call them as non-cumulative. And when we talk about equity shares, how the company will decide the payment of dividend for equity shares? There are basically two things. One is the availability of the profits. The profits must be available, and that is the quantum of profits, how much is available, etc. And the second one is what is the policy of the company as far as dividend. So to cut short, for equity shareholders, the rate of dividend would be based on two factors, availability of profits, and then second one is dividend policy. Now, let's move further. Here we are talking about what are all the sources that we are talking for payment of dividend. Since payment of dividend involves money, outflow of money, what are the sources? Where can I get this money? If we look at the sources are very simple. It must be out of profits. But only thing is either it can be a current year profit or it can be a previous year profit. But it must be profit. Now, or it can be a combination. If current year profits are not that much sufficient, then you can take part of it from previous year and part of it from the current year. And so it can go as a combination. But at the end of it, it must be out of profits. So now, or it can be out of money provided by the central government or state government under any guarantee schemes which are given by where the dividend is guaranteed by the government, that is. So to cut short, what are the two sources that we talk about? One is the profits, either it is current year or previous year. It is like ideally there are only two sources. One is the profits and second one is the government money, where it is on account of government guarantees. But this profit can be out of current year or can be out of previous year or can be a combination. So that is what we are trying to talk about. So it can be a combination. So profit can be current year profit, previous year profits, that is what we call accumulated profits, or a combination of it. If the current year profits are not sufficient, we can draw some money from this current year profits and rest of the money can come from accumulated profits. Or the government, wherever there is a dividend guaranteed to the shareholders, to the investors on account of any schemes or out of any agreements, then that money again can be used for payment of dividend. These are the sources. Now, the most important point is on transfer of reserves. Kindly take 4 stars to it. In your exams, of late, after this 2013 Amendment Act, has been asking a lot of questions on this transfer to reserves. Now, the reason when you read it, actually, it doesn't give you any feel. Why is it so important? Because if you read the statement, they say a company may transfer such percentage of profits as may consider it appropriate. Then it is the choice of the company. It's the discretion of the company. It's the discretion of the management. But then why this point is so important? Because this is what they have changed in this 2013 Act. Now the table that I am showing, it is not relevant for you. These are, don't get confused, these are the old provisions. I am just showing these to you only to emphasize the need for why this can be asked and why this is being asked in the examination. So as far as you need not study all this, but this is only for your back-end knowledge. If we go back to the earlier rules which were there till this act is amended and got amended, there were certain mandatory percentage of profits which are required to be transferred to reserves. That percentage was always linked to the dividend percentage. So there were two things. Based on the dividend percentage, the percentage of profit which you need to transfer was decided. This was the slab, 10 to 12.5. Then you need to transfer 2.5. If it is you want to pay anything between 12.5 and 15, then you have to pay not less than 5%. So there were certain percentages of profit which were required to be transferred to reserves. But this provision is no longer relevant now. So, but this provision is what he has modified, what has been modified here. Now the solution is simple for this. Do you need to by heart the table? No, there is no need for you to by heart the table. Can the company transfer any amount to the reserves? It's its discretion. If it want to transfer, it will transfer. Not interested in transferring, it is up to the management. Say earlier, the logic for this was the shareholders are of two types. One is a short-term shareholder and another one is a long-term shareholder. When you are paying higher rate of dividend, short-term shareholders are more happy, whereas the long-term shareholders, they want that money to be rotated in the company and they are having longer plans. They want that company to grow and they want to grow along with the company. So they would be more happy if that money is retained in the company and used for working capital rather than giving it back to the shareholders. Whereas the short-term shareholders, since they don't intend to continue with the company for a longer period of time, they prefer for a higher rate of dividend. But till this act got amended, the government was planning to balance between both the short-term shareholders and as well as the long-term shareholders. And that is why there were certain, whatever we are talking about transfer to reserves, this is keeping these long-term shareholders in mind, and also the liquidity of the company, the funds, availability of the funds for the future prospects. Whereas in the current scenario, with the change in the business and no company is certain to continue for a longer period of time and the fluid kind of situations, they abolish that mandatory requirement for transfer to reserves. So to cut short, now the provisions that are applicable for you are very simple. Is it mandatory for the company to transfer to reserves? The answer is no, it's not mandatory. Then who would decide how much to transfer or whether not to transfer? It is all the management. So it's completely the discretion of the management. So this word is going to be the golden word for you. So that's all. And he is asking this basis, this small point, he is asking for 4 marks questions, right from MCQ to 4 marks in different forms. He is asking it 1 mark, 2 mark, 3 marks, 4 marks, all the one. All that you need to remember is it is the discretion. And of course, legally we can say that they use the word may. You know that the may is doesn't create any obligation. So shall would have created obligation, but since they have used the word may, it is nothing but the discretion of the management. So now let's look at a question to make you understand this concept better. Look at this question. Alma Limited proposes to transfer more than 10% of their profits to the reserves for the current year before the declaration of dividend at the rate of 12%. Now, is Amla Limited allowed to do so? What they are saying is they want to declare a dividend of 12%, but they want to transfer 10% to reserves. Can they transfer? The rates are really not material. It can be 10%, it can be 30%, it can be 40%. All your answer is going to be, it's the discretion of the management. Yes, the company is free to transfer. They can transfer any amount. So the answer, unless you are well versed with what was the old provision, it may not give you any thrill of what are you learning here. So that was it. Now the mandatory requirement has been abolished, to repeat it, and it is just left to the management. Whichever the rate you want to transfer. So, but then why is he giving 10 and 12? He gives anything. But for you, answer is simple. The company is free to transfer anything. So that is what you can see it as an answer. Then look at the second one. Bricks Limited has earned a profit of 1000 crores for the financial year 16-17. It has proposed a dividend rate of 8.75. However, it does not intend to transfer. So look at here. They do not want to transfer any amount to the reserves, but they want to declare the dividend. So they want to cater to the short-term shareholders, but the long-term shareholders are disappointed. Company is not saving anything, and the company is not willing to save for the future. But nevertheless, can they do it? The answer is yes. It is the discretion of the company. There are no restrictions now because the rules have been abolished. So again, going back to it, this is the golden statement you must remember. Can I transfer to reserves? It's the discretion of the management. They can transfer a higher percentage, or they can even decide not to transfer. That is what you see both the persons in this particular manner. Then let's move ahead. When we say this dividend can be paid out of profits, including the past profits, that is nothing but accumulated profits. Now, accumulated profits can be in two accounts, to put it from your accounting language. One, they may retain it in the profit and loss account itself, or something they would have already transferred to reserves. Now the question comes, can the company use the reserves, which is nothing but accumulated profits of the earlier years? Can the company use them? The answer is yes. But the only condition is only free reserves can be used for payment of dividend. Indirectly, any specific reserves, by very nature, specific reserves have to be utilized for the dedicated purpose, allotted purpose. So therefore, if the company want to declare the dividend out of free reserves, the answer is yes, it is permitted. But what is not permitted here? Specific reserves. Using any specific reserves for the payment of dividend is not allowed. But free reserves, yes. So that is what they are trying to conclude here, which is a negligible point from the examination perspective. Now, moving further, again another small point, set off of previous losses and depreciation. That is, whenever they are declaring dividends, they must be using the profits. So whatever the profit they are using to decide how much can be paid as a dividend, they are supposed to set off from the profits two things. One is carried over previous losses, and second one is depreciation, which is unamortized as of now. So depreciation not provided in the previous year, and the losses. So previous year losses plus depreciation have to be set off, and whatever the balance money that you are having, out of which they can start making the payment of dividend. So this is what the points that he is trying to talk about. Now, before I proceed further, let's take a quick glance of what we have been discussing thus far. To start from the beginning, we started discussing on what do you mean by dividend. Dividend includes interim dividend. And well, then what is the dividend? It is nothing but amount paid to the shareholders as a distribution of profits. Then interim dividend and final dividend. Now, this interim dividend is something which is declared during the year. Therefore, the financial statements are not ready. Whereas the final dividend is something which is declared after the closure of the financial year. Therefore, the financial statements are already prepared and kept ready and even audited. And who would decide? It is the board of directors who would decide on the interim dividend. The shareholders' approval is not required. Whereas when it comes to this final dividend, recommended by board of directors but approved by the shareholders. And where do they need the article specific approval? It is for the interim dividend, where they need specific provision to talk about. But whereas when it comes to the final dividend, it doesn't require any specific provisions. Now, then we talked about the types of shareholders, which you are very clear about it, and then the sources. There are basically two sources. It is profits and government contributions from the government. This contributions from the government is on account of guarantees, dividend guarantee schemes, whereas the profits, all types of profit, current year profit, previous year profit, or accumulated profit, or a combination of it. This is. So put this point in another practical way, which source cannot be used for payment of dividend? Borrowings. That is, a company cannot borrow money to make payment of dividend. So any kind of borrowings, whether you call loans or working capital adjustment, whatever it is, any borrowings are not permitted for. Borrowings can be used for running your company as a working capital management, but borrowings cannot be used as a source for payment of dividend. Whenever you're paying dividend, it must be out of the profits. The only choice is it can be either current year or previous year, but it cannot be from borrowed funds. Now, and then we covered this major important point. How much I need to transfer to reserves? It is the discretion of the management, and the rules which were there talking about the various slabs and percentages and all that, they are not there now. So no much discussion is required. It is up to the company. Either they can decide not to transfer at all, or they can decide to transfer higher percentage. It's all the discretion of the management. And then, can I use reserves as an MCQ? Can I use reserves for payment of dividend? If it is free reserves, answer is yes. If it is specific reserve, answer is no. Now, then, can I use all the profit just to pay off my dividend? The answer is yes, you can use, but after adjusting for two things. One is the losses of previous years plus depreciation, which is not provided in the previous years. After netting of these two, whatever is the profit that is left, they can use it. Now, let us come to this, the other discussion on which he is asking even essay type of questions. That is, declaring the dividend out of accumulated profits. So, if the company wants to use reserves, their accumulated profits for making the payment of dividend, then what are all the rules that are there? A company can still use past profit, that is what we have discussed, as a source, but there are three conditions they need to satisfy. One is the rate criteria. Second one is the amount to be drawn from the accumulated profits. How much amount are you drawing? So, and third one is what is the balance that you are going to leave in the reserves. You can't clean sweep the reserves. So, there must be something, the balance left out. Then what are all the percentages? When it comes to the rate, it is the average 3 years rate. That is what we need to keep in. So, it is 3 preceding financial years. Whatever is the rate that you have paid, average of 3 years is what you need to keep it. This point, how much amount I can draw from the reserves? I should not draw more than 1/10 of paid up capital and free reserves. So, it is putting it in the same way, it is nothing but 10% of my paid up capital plus free reserves. This is my condition 2. And even out of this amount, again as usual, I have to set off whatever we were talking about, the losses and any depreciation, that has to be set off. Only from the remaining amount I can use it for using it. So this is condition number 2. Condition number 3, how much money I am going to leave it in my reserves. As I said, you can't clean sweep your reserves. You can't utilize all the reserves to make the dividend in the current year. Then if the year is not going to be good, how do you survive for the next year? So therefore, the expectation is to leave some balance of reserves with the company, some balance in the reserves. Now, then how much balance I should leave it? They say the balance that you are leaving after drawing whatever the amount you wanted under this two, it should not fall. So it shall not fall below 15%. So indirectly, minimum 15% I should have it in my reserves account. So leaving 15% of reserves, I can utilize any amount. So to summarize, can I make the dividend out of reserves? Yes, you can make the payment of dividend out of reserves, but you need to satisfy 3 conditions. Condition 1, the rate criteria. Condition 2, amount drawn criteria. Condition 3, balance in the reserves criteria. What is the rate that I can pay? Average of 3 years. And what is the amount I can draw? 10% of your paid up capital plus free reserves. Out of this, first I have to adjust for any losses, unabsorbed losses, and then any from the balance I can use it for payment of dividend. And the balanced condition 3, whatever amount I am drawing out of 2, whatever it is, at the end of it, I am supposed to have minimum 15% of my paid up share capital as a reserve in my reserves account. So that is what are the rules as far as payment of dividend out of accumulated profit. But if I want to make the payment of dividend out of current year profits, I really need not look at it. So these conditions would become necessary only if I am using accumulated profits. Now, let's move on. Then the next 123.4 talks about what is the time limit within which I have to transfer the money to a separate scheduled bank account. This I will talk about. All the timelines, I am deferring it now. All timelines, we will talk about it at one go. So temporarily I am keeping it on hold. Now, then again connecting points. Now, interim dividend. As we discussed in the beginning, the definition dividend includes interim dividend. Now, can I declare interim dividend despite having my current year losses? That is what this point is all about. First of all, can the company declare dividend? What should be the sources for interim dividend? There are no separate sources. The definition was very clear. Dividend includes interim dividend. Therefore, whatever are the provisions that are applicable for dividend are also applicable for interim dividend unless specifically carved out separately. Now, so coming back to this, can the company make an interim dividend despite having current year losses? The answer is yes. But however, we had three conditions for whenever you are making dividend payment despite current year losses but utilizing the previous year, there were three conditions. But if it is interim dividend, you do have the conditions, but only one condition. That one condition is the rate at which you are paying should not be more than 3 years average of it. That is what they are saying. In case the company has incurred losses, I will show you the summary of it. It is the simple one. This is with regard to interim dividend. If there is a loss up to the previous quarter, when I say previous quarter, whatever the date you are declaring the dividend, interim dividend, up till previous quarter, in the current financial year, if there is a loss, can I still declare my interim dividend? The answer is yes. But the only condition I need to keep in mind is the maximum rate that I am paying should not be more than 3 preceding financial years. So this point is again important. So kindly note this point, and this one-liner is more simple for you to read rather than this lengthy statement. It will mean the same, but as a summary, if there is a loss in the current year up to the previous quarter, you can still make the payment of interim dividend, but the maximum rate of dividend that you can pay is only the average of 3 preceding financial years. Mark this word. Whenever we are solving questions, it will become all the more important. So, it is the 3 years profit that we take, not the 5 years. It is the 3 years profit that we take. Now, let's move on further. Then payment of dividend. Whom do I make the payment? How do I make the payment? That is what we are trying to talk about. Now, how do I make the payment? Dividend can be paid either in cash or through check or through dividend warrants or through electronic mode, direct transfers, bank account transfers and all that. So they can do all this. Indirectly what they are saying, you can pay cash or bank or even warrants, but payment of dividend in kind is not permitted. That is what you need to note it. So can I make the payment of dividend in kind? The answer is, if the question is this, the answer is no. So either you can pay it in cash or you can pay it through bank. But of course, with the current SEBI rules, dividend can't be paid in cash. It must be through a bank account. But as per the Companies Act, it can be paid. It can be made in any of this mind. But indirectly, they are trying to stress that you can't pay the dividends in kind. This is what they are trying to stress. Now, this is on how do I make the payment. Then the question comes, whom should I make the payment? The answer is very simple. The dividends are paid always to the registered shareholder as on the day of the declaration of dividend. That is, as on the day when they are declaring the dividend, whoever is the registered shareholder, he is the one who would become entitled for it. Either we pay to him or to any of his persons who are to his order or to his banker. Like say he is an NRI, he is abroad, now he wants the dividend payment to be made to his parents staying here, whatever. So to his order, whomever he orders, the company can make the payment to them. And or to his banker, if he has given any bank account and all that, they can make the payment. So, but these two are not so important, but this point he will be asking you. I will elaborate whenever this, through this illustration that is given here. So the payments can be made only to the registered shareholder. This point, otherwise it's not a very, big point it appears, but wherever there are transfers, then understanding of this concept would become more important. That is what he is trying to ask you through your 5 marks questions, 4 marks questions. I will elaborate. I will explain that whenever we discuss this illustration. Let me complete this Nidhi portion. Now, generally we say the company has to make the payment of cash, and what happens if the company is not able to make the dividend payment even within 30 days, the timelines which we will discuss further. Then if the dividends are not collected by the members in the case of Nidhi up to 30 days, then they can transfer, they can credit that amount to the account of the member. So since the Nidhi companies dividends are not going to be that huge, and the shareholders are, the members are predominantly from unorganized sector, so instead of transferring to this unclaimed unpaid dividend account and then IEPF and all, they say if they are not collecting it, you transfer it to their accounts. So that is what is this point as far as Nidhi company is concerned. Now let us analyze this one. As I said, this is important, this registered shareholder. Now how does that imply for your exams purpose? Let's look at it. Let's read this question in detail. You have got several questions in a similar fashion which are asked in multiple. It's a simple concept. Now let me read the question. The director of SOM Limited proposed a dividend of 12% on equity shares for the financial year 2015-16. Note this point. So the dividend is declared for the financial year 15-16. Now the same was approved in the AGM. When they are approving in the AGM, we know that it is the final dividend. Now, and which when this AGM had happened, 2016 September 20. That is when this AGM had happened, in which they have approved the final dividend for the financial year 15-16. Let's look at the next one. The directors declared the approved dividend, and Mr. Ninja was the holder of 1000 equity shares on 31st March 2016, because since this dividend is paid out of the based on the profits for 15-16, keep that point in mind. So this Ninja, he was the shareholder for the financial year. That is what he is trying to say. As on the date of the closure of the year, he was the shareholder, but he has transferred the shares to Mr. Raj. There is another person who bought the shares from N. Now, whose name has been registered on 20th May. So if you look at it, if you analyze this financial years, you take it 15-16 and this next financial year 16-17. Now the dividend is paid based on the financial year. This is based on which they want to make the dividend, based on the this year's profits of 15-16 they want. But when are they declaring? They have declared it on September 2016. This September 2016 would come in this. So here they have declared the dividend, but it is pertaining to the previous year financial year. That is the difference between this. Then who was the shareholder? N was the shareholder as of this cutoff date. So this cutoff date is 31st March 2016. So till this date, he was the shareholder. That is, his contribution of capital was there for earning the profit for this period. And later on, he sold to Raj, who became the shareholder in this financial year. So if you look at it, the dividend was declared for the year 15-16 based on this profits, for which N was the shareholder. And Raj became the shareholder in 16-17. That is the confusion. Now they are asking, though I am declaring in 16-17, but it is for 15-16. So whom should I make the payment? Should I make the payment to N or should I make the payment to Raj? That is where this provision would become important. What the Companies Act says is it's very simple. Whoever is the registered shareholder as on the date of declaration, he is the one who would be entitled to get it, irrespective of the fact whether his contribution was there in that for the year for which you are declaring the dividend. To sum it up, in this case, it is Raj who would be entitled to receive the payment of dividend, though his contribution was zero as far as 15-16, But still, since he is the registered shareholder, as on the day of the declaration of dividend, he is the one who would be entitled to it. So this is what they are trying to say. So the summary is, whenever you decide whom should I make the payment, it is to the registered shareholder. Then as on what date? As on the day when you are declaring the dividend, not the day end of the financial year for which you are making the payment. It is as on the day when you are, like here, this is the AGM. The dividend got the finality only after its approval by the members in the AGM. So as on this date, whoever are the shareholders, or maybe little impractical, they will announce for book closure and all that. Let me not confuse you with multiple examples. So that book closure will be there, all the concepts are there which you study at a different chapter. So as far as this chapter, point is simple. You make the payment of dividend to the registered shareholder, whoever is registered as a member as on the date of declaration. That's it. So this point is going to fetch you 4 marks, 5 marks, multiple questions. Just that this names may change, N may become A and Raj may become another B or C and but concept around this is same. Now let's talk about this. This point is important from MCQ, short answers. You can say short answer perspective. So either short answer or MCQ perspective. Now what they are saying is, there are certain companies which cannot pay dividend. Now, which are the companies which cannot pay dividend? The moment we say prohibition on payment of dividend, section 8 comes into our mind. Because these companies, that is what is one of the feature of this company. They can earn profit, but they are not supposed to declare this profit. They cannot use this profit for declaring the dividend. So, which companies are prohibited from declaring the payment of dividend? 2 set of companies. One is a section 8 company, and if it is not a section 8 company but it is a defaulted under these 2 sections which deals with acceptance of deposits and repayment, 73 and 74, then you cannot make the payment of dividend. So to cut short, there are 2 types of companies. One is section 8 companies and others. Now if you are, because these are all prohibited, so these companies are not allowed to, prohibited from making the payment of dividend. Section 8, yes, in all cases you cannot make the payment, they are not permitted. And this others, only if you are a defaulter. If you are a defaulter of 2 sections, that is what you see here, 73 and 74. Both of them deals with the deposits chapter, where you learn in detail about what does this section 73 deals with and 74 and all. But as of now, these 2 deal with the deposits. So if you have not complied with this 2 sections, then you are not allowed to make payment of a dividend. So that is this concept. Now let's move on to the another one, unpaid dividend account. Take 3 stars to this time. This is what? This is where we will learning the various timelines of it. Now, once dividend, I will take you through this and then I will give you a summary. Once a dividend is declared, within 5 days, they are supposed to keep the money in a separate bank account in any scheduled bank, and from that separate account, the company will start making the payment. Then how many days are allowed for the company to make the payment? 30 days. 30 days are the days, number of days that are allowed for the company to make the payment. What happens if there is any dividend which is not claimed or not paid by the company, or paid by the company but not claimed by the shareholder for whatever the reason, then what happens? Then within 7 days after the expiry of 30 days, they are supposed to transfer to one account called unpaid or unclaimed dividend account in a bank account. So that amount they have to transfer, unpaid dividend account. This is the account to which they are supposed to transfer, unpaid dividend account. What amount they have to transfer? Any unpaid dividend, any unpaid amount, or any unclaimed amount. Both the amounts they will transfer it to this account. So, but where from they are moving it? from the separate bank account, they are moving it to unpaid dividend account. Within what time? 7 days after the expiry of 30 days. Then what happens? Now, then in this account, the money will lie for 7 years. And after 7 years, the money will get transferred to IEPF account. So this is the flow. And for then in between, there is one more concept which is 90 days. That is, after transferring to this unpaid dividend account, what the government is saying now is, many people are unaware that there is an unpaid dividend account which they need to collect from the companies. So therefore, what they are saying is, let the people know that it is their money, they are not collecting it. So within 90 days from transferring to this account, the company will prepare a complete statement. What are the names? Last known address, unpaid dividend account, and that list of unpaid dividend account will be published in two places. One is in the official website of the company, and the second one is website approved by the government for this purpose. There is a dedicated website where you can track all the details through PAN number and certain other numbers and all. There is a procedure. Let's not get into the practical side of it. So they are supposed to keep these details of this unpaid dividend account in two places, their own website and the government website, which is dedicated for this purpose. What happens if the company fails to transfer within 7 days? Then they have to pay at the rate of interest of 12% for transferring. But mind you, this 12%, you shouldn't get confused with 18%, which we will be learning at a later point of time. And from the examination, this 18% is important, but as of now, I am not talking on what is this 18%. So let's close this at this stage, but be mindful that this 12% is totally different, and another 18% which we will learn about the interest that the company has to pay for unpaid dividends. From the exam purpose, that 18% remembering will help you more. I will come to it. Now before I move further, let's summarize the timelines. These are the various timelines, putting it at one place. 5 days. All this starts from your date of declaration. 5 days from the date of declaration, they have to transfer the amount to a separate account. So like you can see, a separate account they have to transfer. From the regular account, they will have to open a separate account and transfer. From this, they start making the payments, and the time limit is 30 days. So this 30 days is for making dividend payment. What happens if there is any unpaid or unclaimed dividend? Then within 7 days after expiry of 30 days, the company is supposed to transfer to an account called unpaid dividend account. This is the nature of the account. Why only this account? This account has a particular limitation in its operation, like how your savings account and recurring deposit account are different in way its operation. So once you open this kind of account, there are no further deposits accepted, and you can't pull the money as it is. So there are certain restrictions, and whenever you are depositing, the banker would ask you whom are the people whom I should make the payment, and the only payments allowed are only this dividend payouts. They won't allow you to withdraw the money after. So let's not get into that banking account limitations, but as of now, within 7 days you got to transfer to unpaid dividend account. And then what do? Then another timeline is 90 days. What is this for? This is for publishing the details of unpaid dividend account. Now, where will they publish these details? At two places. One is the company owned website, and another one is the government website. That's all. So both are websites. One is the company's own website, and second one is government dedicated website. Then the last deadline is 7 years. This is for transferring to IEPF account. And once the money is transferred here, for some point of time they said you can't withdraw the money. But with the amended provisions, even if it is transferred to IEPF, you can still withdraw the money. That provisions we'll see it. So to repeat it, 5 days for transferring to separate account, 30 days for making the dividend payment, and 7 days for transferring to unpaid dividend account, 90 days for publishing the details, and 7 years IEPF account. The same one, if we analyze from the bank account perspective, first you will have the money in your regular account, and from regular account within 5 days it will be moving to separate account. The money will be moved to the separate account, and from here you start making the payments. Any money which is unpaid or unclaimed here will be moved to unpaid dividend account, and from here anything is still remaining unpaid for 7 years, it will go to IEPF. So this table summarizes the movement of accounts, movement between the accounts, movement of accounts from one to the another, regular account to separate account, then to unpaid dividend account, then to IEPF account. Whereas this talks about the timelines. Now, let's move further. Now, this concept, as I said, what happens when the money is transferred to IEPF? That is 7 years, shareholder has not claimed, then what do I do with that? Now, the company set says, after keeping it with you 7 years, waiting for the payment to make, but if the party has not claimed even for 7 years, the company will transfer to IEPF. Once it is transferred to IEPF, it is the government which is there is the dedicated authority who would be monitoring it. Then the point that you are learning is, you don't go too much in details of the forms and all that, but what you discuss here is, can the shareholder claim it back? Now with the amended provisions, yes, the shareholder can claim the money back. But what he has to do, there are certain formalities. Now they will ask you to show that you are the shareholder, some demat account listing and some declarations are there, and you have to give some bond as a guarantee and all those. There are certain procedures. Let's not get into the secretarial practice. But to conclude, can the shareholder draw the money, claim the money even after transferring to IEPF? Answer is yes, but by following certain small procedures. Now what happens when there are contraventions? There are punishments. This I am not really highlighting, we get just about reading the numbers. Now, before we move on to the last key points of it, let's discuss on this IEPF account, which is dealt with in section 125. In this, who is monitoring this fund? What are all the sources? What are all the payments that can happen? That is what we generally being discussed at this stage. Now, since you must be familiar with this, I will quickly wrap it up in the interest of time. Now, this fund is established by the central government. It's not a private fund, it is a government fund and set up by the government. So therefore, the movements of it are monitored and tracked by the government and audited by C&AG. Now, what amounts will get transferred to IEPF? Is it only unpaid dividend account that gets into this IEPF? No. Any money belonging to the securities will go to here. Then that is where he is talking about what all will get credit. One is the unpaid dividend account. Apart from that, any donations by the central government for this perspective, or any amount given by the central government, if not as a donation, by any other budget related sanctions, and amount in the general revenue account of the central government which is dedicated for this purpose, and IEPF under the old Act 1956 Act, income from any other investments, or if you see basically all securities related, let's say unpaid application money, deposits got matured but you have not made the payment, so then that will go, and debentures including the interest, that will go, and sale proceeds from fractional shares arising on account of mergers and all this bonus issues and all, that will go over there, and then any other amount prescribed under Rule 3 of this IEPF. So all this basically it is wherever the company couldn't make the payment, be it dividend, be it deposit, be it debenture, or be it application money, all that unpaid amount or unclaimed amount will be transferred to this IEPF, apart from dedicated transfer by the central government out of budgetary sanctions or out of donations given to them or out of general revenue accounts, whatever that money. Then what is the government going to do with this? How do they utilize this fund? They utilize the fund for this purpose. Refund for the respective dues. That is, if the shareholder comes back and asks, he may be a shareholder for dividend, he may be a depositor holder for deposits, whoever, so they will refund. Second one, promoting the investors' education, like the name suggests, promoting the education and awareness, protection and all. and distribution of discharged amount to the eligible or identified applicants. That is, any ill-gotten money if you have got, that is what is discharged. So that they will distribute it to the identifiable applicants. And then reimbursement of legal expenses. Any legal expenses, not for everyone, but in the case of class action suits. This point, what are class action suits? You study in your share capital chapter. Now, this is again 2013, one of the amendments that they've included. So, if there are class action suits, then any legal expenses that are to be borne by them, it can be sanctioned through this IEPF account. Then any other purposes incidental to all this. So it's basically either to refund to the genuine share deposit holder or a shareholder, or for the kind of shareholders. That is what you see it. Then when it comes to this administration, who would monitor this? The authority. Who is appointing that authority? Central government. Central government appointed authority will monitor it, and then they are the ones who will frame the rules and monitor, though he has given some numbers and all, but in the exam he is not questioning much on that. Then who would be maintaining this accounts and audit and all? The authority is responsible for maintaining the accounts, but they need to take the advice of the C&AG, Controller and Audit General. So with his consultation, the authority will maintain it, and of course, because since it is a central government control, obviously it is audited by the C&AG. So Controller General of India, he is the one who is going to audit it. Then once he is auditing, where his reports are presented, as usual, which you learn in other chapters, C&AG his report will be presented or placed before this House of Parliament or the State of Legislative Assembly. So he will give it to the President or Governor, who shall cause it to be laid before Parliament or the Assembly. So C&AG is the one who does this audit. After that, he will give his report to the President, and the President will present it to this Parliament, House of Parliament. They will give it to the authority to this. So there is a flow, but that detail I don't want to confuse you further, which you learn it in a separate chapter. Now, let's talk about it. Let's take 3 stars to this. 3 or 4 stars here. It's a simple point. What is while talking about this payment of dividend, we said, whom do we make the payment of dividend? Payment of dividend has to be made to the registered shareholder. But what happens when there is a transfer and the transfer is not being processed as on the day when they are declaring the dividend? 99% that situation will not arise. That is why we have this book closure concepts and all, which you study in another chapter, management chapter. But for some reason, if the transfers are not affected, that is, if the transfer is not complete for want of information, for legal cases, whatever it is, if the transfer is pending, then whom the company should pay the dividend? Will they pay it back to the transferor, or will they, because the transfer application is received, will they pay it to the transferee? What they should do? That is what he is talking about. Now, in this, we are going to focus on 3 things. One is the dividend, and right shares and bonus shares. These are the 3 points that you should remember. One is the dividend, and second one is the right share, and third one is bonus share. But all these are regarding pending registration of transfers. Transfers are pending. That is, they have submitted the application, transfer SH4 and all that. They have submitted this transfer applications, but the company could not complete it. Then what the company should do? Whom they should make this dividend, or whom they should issue this right shares, or whom they should issue the bonus shares. Now, instead of confusing with here, let's look at the summary. Any pending transfers of this application of shares, what the company should do? Then, as I said, there are 3 points. One is the dividend, second is the right share, third is the bonus share. The provisions are different. If you are talking about dividend, then the transfer, that unpaid dividend, whatever the money which pertains to this transfer of the shares where the transfer is pending, that dividend will be transferred to unpaid dividend account. So meaning, will they pay to the, see how we have to look at it is, are they paying to the transferor or are they paying to the transferee? They don't pay to both of them. say they are not paying to either of them. They are not paying to the transferor, they are not even paying to the transferee. They are transferring to this unpaid dividend account. Then as the court cases or investigation or whatever it is completes, now they know who is the genuine shareholder, then money will automatically be transferred. Till then, it will be kept in this unpaid dividend account. Now, if it is with regard to the shares, right shares or bonus shares, because this account deals with only dividend, this is unpaid dividend account. But here we are talking about the shares. So this can be transferred here. That is why what they say is, if it is about right shares or bonus shares, keep it in abeyance. So keep this with you. Then till the time it is resolved. Once it is resolved, move it to the respective account. This is what is the point they are trying to. So be sensitive. If it is dividend, transfer to unpaid dividend account. If it is rights or bonus shares, keep it in abeyance. Look at the question, you will understand. Say, in this MCQ, what they are asking, Mr. X is the shareholder of Mark Private Limited. He transferred his shares to his daughter in the month of February. Registration of such instrument of transfer is still pending. So, this is pending by the company. In this scenario, the Companies Act 2013 states certain provisions which have to be kept in mind by the company. Now, will they give it to the father or will they give it to the daughter? Then we have to see what are the three things they are talking about. Are they talking about the dividend or right shares or bonus shares? Now, in this case, they are talking about the dividend. If it is dividend, then it will be transferred to unpaid dividend account. That is what the option we have to look for. Now, company has to transfer the dividend in relation of the shares to unpaid dividend account. Then this appears to be correct. But let's see the other ones and then rule out the possibilities. The second one, company has to transfer the dividend in the name of the transferee. And the third one, transferor. So, and then the bonus shares, fully paid bonus shares and all this. So, as I talked about here, that is how you have to learn. Will they give it to the transferor? No. Will they give it to the transferee? No. Then what do? They keep it in this unpaid dividend account. So, but if it is a right shares or bonus shares, they are going to keep it in abeyance. This is what they will do if the transfer of shares is pending. That is how we have to look at it. Now, let's move forward. This is almost, we have come to the end of it. Another 10 minutes, this discussion would come to an end. Look at it. This is, mark it as very, very important. This is where you have multiple questions being asked on. That is, what happens if the company fails to make the dividend? Say, that is, learn it in a simple way. 30 days is the timeline given for payment. 30 days are over, but dividend is not paid. What is to be done? These are the consequences. Now, but whom do they punish all this? It is to every director, whoever is a party to the default. So, every defaulting, for every default, whoever is the director responsible for it, he would be subjected to these penalties. What are all the penalties? This imprisonment of 2 years and fine of not less than 1,000 per every day. Apart from this, the company also, these two are for the directors, and company also shall pay interest at 18%. This is what, this 18% is what I was trying to tell you, I was talking about here, requesting you to remember it. So this 12% is for delay in transfer, which is not being asked in the exam. But what he is asking mostly in the exam is about this 18%. This 18% would come into picture wherever the company fails to make the payment, has not been paid within 30 days. If the company fails to make the payment within 30 days, then these are the punishments. So that is for the directors and for the company. Imprisonment up to 2 years and fine of 1,000 per day plus interest of 18% per annum. So this is what are the penalties they have to pay. But there may be situations where company wanted to make the payment, but shareholder has given some wrong bank account, or he has closed that account and gone, he has not updated that bank for various reasons. What happens if the company is not able to make the payment? Now, are you still going to send the directors jail for the mistakes of it? So that is what we are learning on exceptions. Otherwise, it's a very criminal offense. So they are going to send you for jail for 2 years. But what if it is not your fault? Now, that is what is being talked about in section 127 as exceptions to it. So, indirectly, in these 5 scenarios, whatever the exceptions, these penalties will not be there. What are that 5 scenarios? First one, if dividend could not be paid by reason of operation of any law, say due to some reason, like the shareholders account has been frozen, or the court has ordered not to make any transfers to that account, for any such reasons, for any operation of law, that is, company is not at fault. They wanted to transfer, but ultimately dividend could not be paid because of any law in place. Then you can't punish the company. It is not their fault. That is why the company is exempted. Similarly, this point is important from examination. Now, when the shareholder has given directions regarding payment of dividend, that is, shareholders would have asked the company, like we learnt about. If you go back here, I am relating whom you can make the payment, either to the shareholder or he has given some order. You make the payment to somebody, or maybe his parents or his friends or his relatives, his brother or somebody, to his order, or to a banker. Then whenever the company is trying to make the payment to them, there are challenges. So then why do you punish the company? That is what he is talking about. The shareholder has given certain directions, but the company could not comply with that. Not the fault of the company. Maybe the shareholder want the payment to be made to his father, but the father had closed the account. Now, then what the name that is given in this, he has given some name, make the payment to my father whose name is so and so. But the bank, in the bank records, his father's name is spelled differently. So the banker had refused to transfer, name mismatch or whatever it is. So the company wanted to comply, but they could not comply with this for want of other details. Then why do you punish this one? But in this case, if there is a name difference, the shareholder has given some name, paid to some XYZ, but the banker had refused, saying the name is not XYZ for that account. Either account error, account number error, or the name error. These kind of technicalities, if the payment has not been, the company could not make the payment, the company is not at fault. But this is important. The company will not be punished for this, provided the company has communicated to the shareholder. So this point is what you need to stretch. ICA has not put it in bold, but there are questions to test your understanding, whether did you understand and notice this point. So therefore you make a note of it. So communication is mandatory. That is, for if the company is not able to transfer because of account number wrong or name mismatch, it is not the company's fault. But what the Companies Act is saying, if this is the case, have you gone back to the shareholder and told him, now the number you have given is wrong or the name is mismatched? That's what the banker is saying. So have you gone back to the shareholder? If you have gone back, then you are not at fault. But if you have not gone back, you have not communicated to the shareholder, then this exemption is no longer. The company is still punishable. So this point is the most important point from examination. I'll show you through the questions. I will take you through it. Then the third one, dispute regarding the right to receive dividend. Wherever there are disputes, wherever the transfers are pending or any legal cases and all, then they are going to keep it in abeyance. So they will not make the payment to anybody. And you can't find fault with the company. So no point in sending the directors to jail. So that is unfair. So that's why this exemption. Then this point is again important for you. Like this shareholders, lawful adjustment. For example, calls in arrears. You have to make the payment to the dividend to the shareholder. Imagine the shareholder has to pay some calls in arrears or any money due from the shareholder. So this is important. Some money is due from the shareholder, but dividend is due to the shareholder. So can we set off this amount? The answer is yes, provided it is lawful. So if it is a lawful adjustment, yes, you can do it. If it is not permitted by the respective law, you can't do it. But otherwise, if it's a lawful adjustment, yes. Basically, they will ask you about calls in arrears. Can they adjust? The answer is yes. If it's a lawful adjustment, they can do it. And the last one, residual. For any reason, any other reason, but the problem, but this is not due to any default on the part of the company. So, for any other reason, like our COVID time, the banks were not functioning, so, and offices were not allowed to go. Maybe the company wanted to prepare the checks, but due to COVID restrictions, nobody could go and work for the office, particularly during first COVID and second this one. And we know the situation was very bad. Any such situations, or the situation in some of the states, violent situations and all, where people are not able to move out, so due to riots or bans or whatever. So it is not fault of the company, and due to the situations beyond the control of the company could not stick to this 30 days limit. Then you can't punish the company, because it's not their fault. There was something else. The problem was somewhere else. The fact is, company has not made the payment, but not due to the fault of the company. So in such a case, you can't punish the company. So to sum it up, let's discuss this and then we'll move quickly to the questions. What are the time limit given to the company for making dividend payments? 30 days. What happens if you are not making within 30 days? Then every director in default is liable for the punishment. Then what are all the penalties? Imprisonment up to 2 years, and for every day you are defaulting, 1000 rupees you have to pay. Apart from all this, from your examination perspective, this is more important. He is asking 5 marks questions merely based on this 18%. So if you delay the payment beyond 30 days, then the company will have to pay the interest at the rate of 18%. But this is a simple interest, not a compounded one. It's a simple interest at the rate of 18%. But will the company be punished in all cases where the payment is delayed more than 30 days? No. In these cases, the company is not found to be fault. So therefore, though the payment is not made, the directors will not suffer any penalties. That is why we call this as exemptions. From exemption to these punishments. That is what we have to say. What are all that 5 cases? One is due to operation of law. Second one, shareholders' directions could not be complied. But here, this is important. The company should have communicated. If you have not communicated, you still suffer the penalties. You have to make the penalty payments. But you have communicated, then it is not your fault. The shareholder has given wrong details. What is that you can do? So if you have communicated to the shareholder, then you are not liable for penalties, or else you are liable for it. Then the third one, dispute regarding the right to receive dividend. If there is any dispute in the right to receive dividend, then you would have kept it in abeyance, so the company can't be found fault with. Next, lawful adjustment of any dues that are receivable from the shareholder, and for any other reason, but this point is important, not due to the fault of the company. Then in all these cases, these penalties will not be levied. So with this, we are done with this chapter, and now quickly I will take you through this ICI questions so that our entire discussion on this would come to an end. Let's look at it. MCQs first, which are given in ICI MCQ booklet, which was issued in 2022. Though there is a change in the syllabus, but this chapter has not changed much. So we can still depend on this, because the new MCQ booklet has not yet been released. So we are entitled to rely on this further. Now, dividend once declared should be paid within. We know the answer. So once you make the payment, declare the dividend, then dividend has to be paid within 30 days. So within 30 days, you have to make the payment of this dividend. Now, which of the following amount need not be credited to Investor Education and Protection Fund? As I said, for this, all kinds of securities, so money related to securities will come. Look at it. Unpaid dividend account, yes, it will go. Matured deposits account, yes, it will go. Matured debentures, yes, it will go. But profit and sale of asset, there is nothing to do with the security. So this will not go there. This is not directly belonging to any investors. So this is the answer. So this money will not be credited to it. Moving further, amount to be transferred to reserves out of profits before declaring any dividend. Like we talked about, what is the percentage of transfer of profits to reserves? Now they have abolished. It is completely the discretion of the company. So that is what we have discussed. If they want to transfer, they will transfer. They don't want to transfer, they will not transfer. Then, next MCQ. the authorized, and just, yeah, now it must be clear to you. The authorized and paid up share capital of this Avantika Ayurvedic Products Limited is 50 lakhs divided into 5 lakh equity shares of 10 each at its AGM held on 24th. This is the date of AGM. They have declared a dividend of 2 rupees per share. Now what is he asking? He is asking, mention the latest date by which the amount of dividend to be deposited must be deposited in a separate account. As I said, this is the reason I have taken you through this timelines vis-a-vis the summary that I have given, movement of accounts. From which account it moves to what account? From regular account to separate account, it moves after 5 days. So 5 days from the date of declaration, from your regular bank account, it should move over there. So now that is the point that he is asking. So within 5 days you are supposed to move. So when you have declared it on 24th September, using our General Classes Act, how do you know that? Exclude the first in the series and include all those points. So 29th September would become 5 days is what is the limit over there. Now, because you have declared on 24th, within 5 days you are supposed to transfer. Now, this case, look at it. The directors of Silver Tongue Solutions Limited proposed a dividend at 18% on equity shares for the financial year 18-19. The same was approved in the AGM held on this 30th September 19. So this is 2021. So this is 18-19 and this is 19-20. 19-20 they have declared, but it is pertaining to 18-19. Now Jagan was the holder of 2000 equity shares as of 31st March. It is similar to the one that we have discussed earlier, Raj and Ninja and all that, same cases. So Jagan was the shareholder for this period, but later on he transferred the shares to Rajiv. So Rajiv is the shareholder for this period. So since this has happened on 8th August, but whereas the AGM had happened much later to it, so indirectly, as on the day when they declared this dividend payment, Rajiv is the shareholder. So therefore, who will get the dividend payment? The dividend payment will be given to Rajiv because he is the one who is holding it. Now, but let's see. That is what to the registered shareholder. Let's see, is it what he is asking? Now, Mr. Rajiv sent the shares together with the instrument of transfer, our SH4, to the company for registration of the shares in his favor. It has been transferred, but he has submitted. The transfer is not complete. So if the question is ending here, then it is similar to our Raj question. You will say yes, make the payment to Rajiv, but he has given continuation. So we will have to look back. So let's cancel this answer. Let's see the remaining piece of it. If we still believe it has to be paid to Rajiv, we will take it. Now, what is he saying further? Now, Rajiv sent the shares together with the instrument of transfer to the company for registration of shares in his favor only on 25th September 2019. He delayed it. So he has not sent the documents. He had sent it only on 25th. The registration of the transfer of shares is pending. So this point is important now. So the shares, the transfer is not complete. We have already talked about it. If the transfer is not complete, then any dividend out of it, we know that it has to be transferred to unpaid dividend account. So in this pending transfers, if it is dividend, it will go to unpaid dividend account. If it is bonus shares or right shares, the company would have kept those in abeyance. So it is the same point that we have talked about earlier. Now, then look at this. The board of directors of Giprise Pharmaceuticals Limited wish to declare interim dividend in the last week of July 18. The company has incurred a loss during the current financial year. So this is important. The company had suffered loss during the current financial year. So there is a loss during the current financial year. However, now what dividend they want to declare? They want to declare interim dividend. Now, however, it is noted that during the previous 5 financial years, so he is giving the data as far as 5 financial years. But we know wherever you are declaring interim dividend, That too when there is a losses during the current financial year up to the previous quarter, you can still declare, but the maximum rate is average 3 years. But he is given 5 years. This is what I was alerting. He may give 5 years, but what you need to consider is only 3 years. So then what will you do? Since it is for this year, the last 3 we will take. So these 3 we will take. Then these are not relevant for us. We will not consider. So 12, 11 and 10. So if we take the average of it, it is 11. So 11 is the percentage what they can declare this interim dividend. So the answer is, what is the maximum rate they can pay the interim dividend? Average of 3 preceding financial years. That's all. It is not the 5. This is what I was alerting you. Kindly be sensible and kindly get sensitized. 5 years he will give just to confuse you. If you simply take the calculator and take an average of it, then you are wrong. You will get a wrong answer. So there is no, you need not consider 5 years. The Act talks about only 3 years. So then you have to ignore the 2 years. We are not concerned with that. Just to mislead you, he will give you that. Then look at the other set of multiple choice questions which are given in our ICI material itself. Then what are these MCQs? These are out of your MCQ booklet. So that we have to, as I said, that they have, which is available in the ICI portal itself. Now, then as per the ICI chapter material, what are all the questions he has given? When dividend is declared at the AGM, we know that. Interim dividend is something which is declared during the year, and final dividend is something which is declared in the AGM, which is approved. So it is the final dividend. Simple point. Let's move. Then amount to be transferred to reserves out of profits before declaring. This point he will continue to ask. It was there in MCQ of MCQ booklet. Again it is. It is the discretion. That is why I was requesting you to take 3 stars to it. It is the discretion of this management which would determine here. Then the same one, the earlier what we have discussed, there are 5 years the company wanted to declare this interim dividend. It's the same case that we have discussed just now. Interim dividend, and the company is still into losses, has suffered losses during the, well, just that he has changed the names of it, but it is the same question. And then again here also he is giving 5 years, like just now I have alerted, he may give for 5 years, but you don't have to consider 5 years. You consider only last 3 years. That's all. So when you consider, you will get this average of 11%. Same. It is the same question that we have discussed here, just that the name of this company is different. Here it is Jiprise Pharmaceuticals, and here it is Vidyut Limited and all. But the point is same. So again, as a matter of repetition, wherever you are paying interim dividend, despite having losses in the current year, maximum rate should not exceed more than 3 years average. That is what you need to remember. Now, then this one. The amount accumulated in the investor IEPF account shall not be used for. What are the purposes it is not used for? Say, refund to the genuine people, whoever are it, yes, it is permitted generally. And reimbursement of legal expenses, as I said, class action suits and all, which is 2013 amendment, Act amendment, it is permitted, legal expenses is permitted. And grants or donation to the central government. You can take the grants, it can be a source, but it can't be the payment of it. So it can't be the utilization. So since he is saying to, this is not permitted. You can take the donation or grant from the central government, but from this you can't give it to the central government. So this is not permitted. In fact, what he is asking is that only. So that is for whom this payment should not be made. That is what he is asking. So the payment should not be made for this one. You can't make the payment to the central government. Again, I am repeating. You can receive the money from the central government, but you cannot make the payment to central government. And is discharged ill-gotten money, as I said, this one is also permitted. So this is permitted, this is permitted, this is permitted. This is not permitted. Why it is not permitted? Because they are saying it is to the central government. If it is from the central government, even as a source, it is yes. But as a payment, you can't give it to the central government. Now, next one. In case a company fails to pay declared dividends or fails to post dividend warrants within 30 days, So he's talking about 30 days is the time for payment of the dividend. What happens if the company is not making the payment within 30 days? Then we know this is 18%. This is what I was telling you. This one will come multiple times in your examination. As short answer MCQ, I will also show you the questions, how it can come. So this 18% is the penalty. Then what is 12%? 12% is delay in transfers beyond 7 days after the expiry of 30 days. Now, let's come here. These are the descriptive questions. We'll cover them and then close. The AGM of ABC Bakers Limited held on 30th May 2022 declared a dividend at the rate of 30% payable on its paid up equity share capital as recommended by the board of directors. However, the company was unable to post the dividend warrant to Ranjan, the equity shareholder, up to 35. See, when did they declare the dividend? Say on 30th May is when they have declared the dividend. Until July, they have not made. But for making the payment of dividend, we know they give 30 days. But he has exceeded 30 days. Therefore, the shareholder had filed a suit against the company. So he filed a suit against the company for making the payment along with the interest rate of 20%. Here we are talking about, if you don't make the payment within 30 days, the rate of interest is 18. But here the shareholder wants 20%. Now he is asking whether will he succeed in the case. He can ask for the interest but not 20%. So that is what you are supposed to highlight. So he will succeed if he is asking for the maximum interest rate of 18%. But if you want 20%, then he will not succeed. That is how you have to answer. See here itself. This is MCQ, 18%, same 18%, he has framed a 4 marks question. That is the weightage. That is why this chapter, the question can range from an MCQ, this 4 or 5 marks one. Now, look at the next one. The board of directors of Feature Fashions Limited at its board meeting recommended a dividend of paid up equity capital, which was later approved by the shareholders in the AGM. They have approved, so the AGM has been declared, recommended and approved by the members. Thereafter, directors at another meeting, they decided, they passed a resolution for diverting. So, for diverting the total dividend to be paid for the purchase of some certain short-term investments. Now they are changing their process. Now, as a result, dividend was paid to the shareholders after 45 days. So, it is more than, for you, it is more than 30 days. Because 30 days is the limit, they have delayed it more than 30 days. Then they are saying, what are the consequences? So, he is asking about, what are my consequences? What are the consequences? As we talked about, consequences are 2 years imprisonment, 1,000 per day and 18% interest. That is what we talk about it. Now, look at the next one. Referring to the provisions of Companies Act, examine the validity of the following. The Board of Directors of ABC Tractors Limited proposes to declare dividend at the rate of 20% to the equity shareholders, despite the fact that company has defaulted in the repayment of public deposits. This is important. So, the company has defaulted. As we discussed, 2 set of companies can't declare the dividend. One is Section 8, second one is whoever are the defaulters of 73 and 74, which deals with public deposits. It's a simple one. Since they have defaulted, they cannot forget about 20. They can't declare even 1%. They are prohibited from making the declaration of payment. Then, next one. Star Computers Limited declared and paid dividends in time to all its equity holders for the financial year 21-22, except in the following 2 cases. They made the payment to everyone except these 2. Now, what are the 2 conditions? Let's see. Here, the Sheila Bhatt, holding 250 shares, had mandated the company to directly deposit the dividend in her bank account. So, she has ordered the company, whatever the dividend she is supposed to receive, she wants that money to be credited to this bank account. The company accordingly remitted the dividend, but the bank has returned the payment. Why they have returned? Because there was a difference in the surname. So name mismatch. But whose mistake it is? It is the shareholder. So she gave wrong details. But in such case, company cannot be punished, but with one condition. So this question is similar to what I was alerting you here. The shareholder has given directions. In this case, it is exemption is available provided the company has communicated. This is why I was telling you this point is important. And in this case, let's see whether the company has communicated or not. Let's look at it. Yeah, it's here. So the company, however, did not inform. So when the company is not informing, then what is the solution? Then penalties are applicable. That's all. You didn't inform, so therefore penalties are applicable for them. So that is what you are supposed to write it. So exemption is not, they can't take the benefit of exemption. For one simple reason, they did not inform. Otherwise, this is not your fault. This is not the company's fault, but this is the company's fault. Next one. Dividend amount of 50,000 was not paid to the successor of late Mohan in view of the court order. So there is a court order of restraining the payment. So this again is talking about you have to take this one for operation of law. So because of operation of law, the company could not make. Then what's the fault of the company? Why do you punish the company? So exemption is available. So going back to the same question. So because it is on account of operation of law, company will not be punished. That is why we will say that the penal provisions are not applicable. So are not applicable here. So you have to elaborate, you know the manner of answering. You have to write that facts and provisions and justifications and conclusion. But this is the answer that you will be writing. Then let's cover two more questions. Thereafter all questions are of a repetitive in nature. Now, this Alpha Herbals, a Section 8 company, is planning to declare a dividend. Now you know it. Once it is a Section 8 company, how can they declare dividend? So it is not permitted. Whatever may be the number of shares, they are not permitted. Now, just to remind you, two set of companies can't declare the dividend. One is Section 8, other one is the company is defaulting in the acceptance of deposits, 73 and 74, acceptance and repayment. So those, because it's a Section 8, not permitted. And earlier he is talking about defaulting in the payment of deposits. That is why this chapter is a small chapter and everything you have a chance of coming in the examination. Now let's look this 6 and 7 and then we'll close. Now, YZ Medical Instruments Limited is a manufacturing company and has proposed a dividend of 10% for the year 22-23 out of profits of the current year. The company has earned a profit of 9-10 crores during the year 22-23. The company does not intend to transfer, so they don't want to transfer any amount to the general reserve. It is their wish. That's what we have been talking about. It is the discretion of the company. They may transfer or they may not transfer. It is the discretion. So can they do it? Yes, they can do it. They need not transfer. It is the right of them. Now, look at the next one. PQ Limited declared and paid 10% dividend to all its shareholders except Mr. Kumar holding 500 equity shares, who instructed the company to deposit the dividend amount directly into his bank account. So he had wanted that money directly to the bank account. The company accordingly remitted, but the bank returned the payment on the ground that account number given is a mismatch, doesn't tally with it. So due to account number mismatch, it didn't happen. Then, but what is this is the same situation. What the company should have done? The company should have informed. But here, the company did not inform. So when you are not informing, this is where the problem comes. So the exemption otherwise available to you is not available. Then is the company subject to penal provisions? Yes, the penal provisions are applicable. Why are they applicable? Only for this reason. Because you did not inform. Not for not making the payment. It's not your fault. But not communicating to him is the company's fault. Therefore, they are liable for it. This is what it is. And thereafter, all the questions by now itself you would have realized it's all are of routine nature. So, in the interest of time, let me stop at this point of time on this questions. Now, it's all the same questions. Whatever we have been talking about, it's the same one. Preceding 3 years and all that, it's a same one. Whatever we have talked was exactly ditto to ditto. Despite losses in it, can the company make the payment of dividend, interim dividend, all the same points. So, to summarize and give you a grip on it, or having opened, I'll just cover this. Otherwise, this may look like we are closing it in midway. I'll just read this out. I'll cover this May 23 and then close. ESPN Heavy Engineering Limited is a listed entity engaged in the business of providing engineering solutions to clients across the country. The company followed consistent growth over the years. Rate of declaration of dividend in the immediate preceding 3 phases. So this is what is the dividend they have been paying in the last 3 years. So is given this is the dividends they have been paying. Now, unfortunately, due to obsolescence of a special part of the machinery, I'll enlarge it. So, machinery, company incurred losses. So, the company suffered losses in the current financial year. Now, even though the company declared, so despite losses, the company had still declared this interim dividend. By now itself, we would have understood. So, whenever you want to declare interim dividend, but actually there are losses in the current year, can they declare? The answer is yes, you can declare. But only thing is the maximum rate should not exceed more than 3 years average. That's all what you are supposed to answer. So, but that is what you talk about it. Now let's read completely. The board of directors of the company approved the financial results for the 21-22. So they paid that interim dividend 10%, which should not exceed the average of 3 years of dividend, which is in line. So 10% is less than the average of 3 years. So till here there is no problem. Now let's continue. The board of directors of the company approved the financial results for the financial year 21-22 in its meeting held on 5th August and recommended a final dividend of 15%. So the board has recommended 15%. In the general meeting, the shareholders was convened on 31st August 22. The shareholders of the company demanded that since the interim dividend was 10% was declared, so the final dividend shall not be less than 20%. So the whole catch is board has declared 15%, but the members want 20%. So it is our very basic concept. Can the members ask for higher rate of dividend than recommended by the board? The answer is no, it is not permitted. So they can reduce this what is recommended. They can say no, we don't want 15, give us 10, that is sufficient. So they can reduce the rate what is recommended, but they can't insist for more percentage of rate of dividend than what is recommended. So this becomes the ceiling, 15%. But the shareholders are demanding this. That is what he is saying. The company secretary emphasized, this is what he is trying to say. The company secretary emphasized that the final dividend cannot be increased because they can't make the payment, because in the AGM you can't decide 20%. It's not possible. For simple reason, the board has recommended only 15%. So therefore, making this 20% payment is not possible. That is what you need to answer. So including the current year questions, not to worry, all are very simple and straightforward questions. And the only thing, if you see what are all the key important points out of this, first one, transfer to reserves. Now transfer to, I'm just giving this concluding remarks and then we will close it. We'll just make try to recollect all the important point that you should be remembering. If you see all this, majority of the questions are on transfer to reserves. So this transfers to reserves, it is a discretion of the management. There are no limits on, they can transfer higher percentage or they need not transfer percentage. So it is the choice of the management. The second point is, what are the timelines given? So 5 days, 30 days, 7 days, and then 90 days, and then 7 years. That, and then what are the movements of the account? Within 5 days, you are supposed to move it to separate bank account. From there, after 30 days, if you have any unpaid or unclaimed amount, will go to my unpaid dividend account, and from there, it will go to my IEPF account. So after 7 years of it. Now, then the additional point where he is asking multiple questions are section 127. That is, what happens if the payment is not made within 30 days? If the payment is not made within 30 days, there is an imprisonment of 2 years and a penalty of 1000 per day of default. Along with that, they also have to pay 18% rate of interest. So that 18% rate of interest is also important. So one point was on transfer to reserves. Second point one was about payment not happening within 30 days, including the exceptions. And the third and the most significant point, interim dividend despite having losses. Now, interim dividend can be declared despite having current year losses with one condition, that is the maximum dividend rate shall not be more than 3 years average of it. So when you revise, keep a look onto this exceptions for this section 127, whereby the penalties, penal provisions are not applicable. So if you quickly revise on whatever we have discussed, you are sure of scoring sums from this topic. So not to worry about it, be confident, and this chapter is going to get you this minimum 5 marks to it. So that is what is an average weight of it. So if we go back to it, let me go back to it. So if you look at it, so these are all the questions that they are asking till here. This is an expected one. So, but because it is CA exams, nobody can say that, but this is what is expected. So it's going to be around the same 5% of it. So this is what we are expecting it to be. So of a 5 marks somewhere around. Why are we expecting? Because even if you look at the current weightage of ICAI is again out of the 4 chapters, the weightage, general weightage is giving is 30% of it. So therefore, you can expect still somewhere around 5 marks in line with this previous attempts, the same percentage will come. So this is what is expected based on the weightage that they are talking about here. So this is a simple chapter. Hardly it will take you not more than 1 hour maximum time to get a grip on it. But whenever you are revising, whatever the points that we have highlighted with this 4 stars, 3 stars and all that, kindly have a look at it, revise it properly. It's a very simple chapter, and 4 or 5 marks are going to be yours. So with this, I will conclude my remarks. Wish you all the best. Thank you.